This is the first video of weeks 3 to 4 in the crimes course. It's a screenshot of the posting regarding the general principles of criminal responsibility. So if you will, we're changing our focus from the court systems and how cases are processed by the criminal court system, and we're now focusing on what is used, or what principles are used to assess whether or not a person is criminally responsible for that person's conduct. We're looking at Article 15 of the New York Penal Law, and what we are starting is simply identifying a general theory of criminal liability, which is the combination, if you will, of conduct and state of mind. Conduct, let's call our actor the defendant. The defendant has done something or not done something, and then state of mind, which we'll explore a little bit more later. But what we could say is that there's no guilty state of mind, then almost always there will be no criminal liability. And the example I use is a driver who's complying with all the rules of the road, is not impaired in any way, is driving carefully, and a person walks in front of the car. It's an unavoidable collision with the person. In other words, there's nothing the driver could have done, no matter how careful the driver was, to have prevented the collision. And the person who's been struck by the car has been killed. Now, what I'm going to suggest to you is that though we have conduct, the defendant was driving a car that collided with a person and killed that person, there's going to be no criminal liability because there's going to be no guilty state of mind, which then calls in the question, of course, what is a guilty state of mind? But let's put that on hold just for a second and focus a little bit on conduct, and the Latin term that was historically used for conduct in a criminal case is the actus reus. In the New York State, the actus reus, or the conduct part of criminal liability, would consist of either a voluntary act or an omission. And so the voluntary act is a bodily movement performed consciously as a result of effort or determination. And as I point out, almost all of our criminal conduct is going to consist of a voluntary act. And let me go one step further and say that most of our conduct as humans is a voluntary act, meaning our actions throughout the day are bodily movements performed consciously as a result of effort or determination. It's a very broad definition. I would think that if we wanted to look at situations that didn't constitute a voluntary act, we'd have to identify something like a person has gone into a seizure due to some medical event, or a person is literally, as people like to say, literally doing something in his or her sleep. But most of the time our bodily movements certainly are voluntary acts. There could be a situation where a person has done nothing, and that might be a predicate for criminal liability, and that calls into play omission. And omission really is where we have a person who has failed to act, where there's a legal duty to perform the act, and we can also add to that the person is physically capable of performing an act. A key component of the definition of omission is a legal duty to act. So if you're the parent of a child, you certainly have a legal duty to take reasonable steps to ensure the health, safety, and welfare of the child. And if you don't perform that duty, in other words, you haven't acted when you should have, and you were physically capable of performing the act, then that would constitute an omission. On the other hand, if I'm driving home later today from my office and I see somebody on the side of the road who's obviously in some kind of distress, I may feel a huge moral obligation to do something to come to that person's assistance, but there's no legal obligation in New York State for a person to go to the rescue of someone who's a stranger, unless somehow I had placed that person in the first instance in that situation of peril. And since I didn't, my failure to act would not, even if I was physically capable of performing that act of rescue or calling 911 or something like that, putting a blanket on the person, the fact is I had no legal duty to act, and therefore there could not be an omission. Our next order of business is to look at the culpable mental states, the so-called mens rea. In the New York State, as we look at Article 15.05 of the Penal Law, we have four mental states. They are different. We have intentionally, we have knowingly, we have then the last two, recklessly and criminal negligence. And what I'm saying to you is that if there is a crime in New York State, that crime will be defined in a way where the government would have to show that the defendant acted intentionally in some way. The crime's definition would tell us that, or knowingly in some way, or acted recklessly or with criminal negligence. So one area where we see intentionally is homicide, intentional homicide. What do we mean by that? Well, if we look at the definition of intentionally, the key component is a person acts intentionally if the person has a conscious objective to cause the result or to engage in such conduct. Well, how do we know if that was the person's conscious objective? Some of the time, as the saying goes, actions speak louder than anything else. So if you were to see someone stab someone with a dagger in the chest area, my guess is you're going to say that that act alone permits you to infer that the person acted with the intent to kill that person. That was the person's conscious objective. Some of the time, possibly, it's what the defendant has said about the defendant's conduct that may also shed light on intent. Another way intent possibly could be established, if need be, is motivation. Did a person have a motivation for killing someone? And what I say is that motivation could be considered indirect evidence of intent, or a fancy way of saying it is motivation could be a circumstantial evidence of intent. Knowingly, the key component, as I say, of that element, is definition, is awareness. Some crimes, for example, crimes of criminal possession, require the government to establish that a person knew that that person possessed stolen property, knowingly possessed stolen property, or that they knowingly possessed an illegal substance. The government would thus have to establish that the defendant knew that the property was stolen, was aware that the property was stolen, or that the defendant was aware that the product was illegal. Oftentimes, the awareness or the knowing is pretty easy to establish by other circumstances in the case. I don't think that intent and knowledge, or intentionally and knowingly, really cause us any real conceptual difficulties. They may call into play close questions of fact, but not conceptual understandings. The two culpable mental states that require some explanation, it seems to me, is recklessly and criminal negligence. And any system of laws that wants to put together a penal code has a challenge, and the challenge is under what circumstances, if any, should a person be criminally responsible for his or her unintended conduct, or the unintended, better said, the unintended results of his conduct. I think we all can agree that if a person intentionally hits another person and causes injury, that's a crime. But what about where, to coin the term, right, an accident, that there's an accident and someone dies, or there's an accident and someone is seriously injured. So now that system has to come up with a concept that somehow satisfies the need to show that there should be criminal culpability for conduct. And the way, in the Western world at least, that's been resolved, and certainly in New York, is by the concepts of criminal negligence and recklessly. As a building block, we could start out just with the concept in the civil law of negligence, which I have up on the screen. Negligence by itself is not a crime. It may lead to a lawsuit if you're hurt in a car, etc., but that's not going to be criminal conduct, merely negligent conduct. But we have to understand negligence to get to criminal negligence and recklessly. So negligence itself requires us to look at the actions of a fictional person, the reasonable person, who approaches any situation with the appropriate amount of caution and then sensibly takes action. Are we the reasonable person? Well, some of the time I am, and some of the time I'm not. The other morning, when I left my home to get to my office, it had been so cold that I had a layer of ice on the windshield that I hadn't expected to encounter. And I left the driveway with the windshield not being entirely clear of ice. Would a reasonable person have done that? No. I think the person who is a reasonable person all the time is probably a pain in the neck. But certainly I didn't comply with the standard that a reasonable person would have followed. And had I, for that reason, been involved in an accident, the argument could be that I was negligent. But by itself, negligence or mere negligence is not a basis for criminal liability in New York. So what we're going to do is stop this video knowing that we've reached negligence, and we'll pick up with this screenshot and get into recklessly and with criminal negligence.